Good morning, good afternoon, good evening, and a big welcome to Honorable Justice Vasheist Kokaram, Judge, Court of Appeal, Supreme Court of Trinidad and Tobago, guest speaker of the session today. Honorable Judges, Mediators, Mediator Advocates, to-be mediators, ladies and gentlemen. A great thanks to all the guest speakers, hosts, and participants who have been with us from the opening ceremony of the 4th International Virtual Summer School conducted by Nivaaran, along with Singapore International Mediation Center and Commonwealth Lawyer Association. It has been a wonderful confluence of mediators and mediation enthusiasts from all over the world during their 4th International Virtual Summer School. Every moment spent during the summer school has been educative, meaningful, and effective. Thanks to the team Nivaaran, SIMC, and CLA for making all this possible. I am Aruneshwar Gupta, Senior Advocate, Supreme Court, the host of the final session today. Coincidentally, I walked into Supreme Court on 1st of August 1976, exactly 47 years from today, and I've been practicing at the Supreme Court since then. I've enjoyed every moment of my profession and has continued to grow with it. It has been a very interesting journey dealing with all kinds of disputes. I've made efforts and have been successful in getting almost all matrimonial cases that came to me ending into living together or a golden handshake. It's my firm belief that if the advocates join hands together and not think of scoring point over each other, it is possible to mediate and resolve every case amicably, except those where the person breaching the trust is not willing to return back the benefit he has received as a result of the breach of trust. I am a promoter of peace mediation, which according to me is a legal revolution 5.0. Peace mediation, as contradistinguished from mediation simpliciter, is not a process of merely deciding a dispute or disposing of a litigation by bringing about a settlement between the parties for the present. Peace mediation is a process of eliminating and eradicating the conflict itself forever. The process entails exploring and exposing the error by understanding the perception, which forms the very basis of the disagreement and brought about the clash of interests. We all have differences, but the day we stop respecting the differences, the conflicts arise. And these differences, they form the basis of disagreements that bring about the clashes of interest. Quality peace agreements must result in combusting and resolving the base or the substratum of the conflict forever. The purpose of mediation, the purpose of peace mediation is to make every person become conflict-free by understanding the basis and true nature of the issues agitating deep inside them. Our constitutional goal is not a casteless society or a classless society. The real constitutional goal is development of a conflict-free society. Lawmen have a pivot role in this paradigm as a lawman, not as a politician or a social reformist. During these 9 days, we heard 10 guest speakers covering 26 topics on mediation. We started with historical perspective of the dispute resolution. It took us back to the first failed mediation by Shri Krishna between Kaurav and Pandav, and the failure of mediation led to the Great War of Mahabharata, which consumed 4.5 million gallant warriors, the best existing at that time. Today, as the curtain falls, we deal with the way forward. We are on the 27th and the last topic, United Nations Sustainable Development Goals and Mediation. No other person than Justice Vasheist Kokaram, Judge, Court of Appeal, Supreme Court of Trinidad and Tobago, with his holistic experience in mediation, could have been apt to expound the subject as we draw the curtain on the 4th International Summer School today. Of course, with a closing ceremony coming tomorrow. In July 2012, United Nations had issued key fundamentals that should be considered in mediation process, preparedness. The party should be ready and willing to mediate. They're the first principle. Consent, impartiality, inclusivity, national ownerships, international law and normative framework, coherence, coordination, and complementary of the mediation effort, the quality peace agreements. In September 2015, United Nations set 17 Sustainable Development Goals for all the nations and is looking forward to achieve them by 2030. Some of these goals are end of poverty in all forms everywhere, end hunger, achieve food security and improved nutrition, and promote sustainable agriculture, ensure healthy lives and promote well-being for all at all stages, ensure inclusive and equitable quality education, promote lifelong learning opportunities for all, promote sustained, inclusive and sustained economic growth for full and productive employment and decent working for all, reduce inequality within and among the countries, strengthen the means of implementation, revitalize the goals, global partnership for sustainable development. Mediation is a sub-silentio part of Goal 16 and is known as SDG 16, promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. The goal is 12 targets and 23 indicators. As the world will move to achieve these sustainable goals, there will be disruptions and disagreements, which will lead to conflicts, agitation, and disputes. As the world continues to move towards creating a civil society, there will be people with vested interest to resist the change. It is imperative that these conflicts are resolved by mediation among those with clashing interests to sustain harmonized and peaceful society. Else, we will see collisions, fights, battles, and wars, some of which are already going on around us. Singapore Convention on Mediation Settlement, about which we heard extensively yesterday, was a step forward in implementation of the same set goal. We all are eagerly looking forward to hear in detail on SDG 16 and mediation from our Chief Guest, Justice Kokaram today. Justice Vasheist Kokaram has been living mediation for last over 2 decades. He is a living legend in the world of mediation. He has been an associate tutor at the high school at the Hug Wooding Law School from 2005, where he induced mediation in schools. As a tutor in civil practice and procedure, he promoted the development of settlement plans as a key component in the attorney pre-action, case management strategies, and the development of collaborative law practices. Justice Kokaram was appointed as community mediator under the Community Mediation Act from 1998 to 2005. He served as a temporary High Court judge in 2006 on a backlog reduction project in which he began to use judicial mediation. He is also a judicial settlement officer from 2009 to date, conducting judicial settlement conferences in the commercial, family, and appellant matters. He has conducted JSC sensitization and training sessions of registrars and family court judges. Justice Kokaram was chair of the court annexed mediation pilot project in 2010 and currently a member of the ADR implementation committee in the Supreme Court, Trinidad and Tobago. He is a certified judicial trainer, UCL Judicial Institute. Justice Kokaram was the chairman of the Mediation Board of Trinidad and Tobago, MBTT, 2010 to 2018. As chairman, he advocated the use of application of mediation as a means of developing a more peaceful and productive society. He led several public educational campaigns and mediation from 2010 to 2018 at the MBTT, which convened several national annual mediation symposiums and also produced publications of mediation and certification. Justice Kokaram served as a judge of High Court from 2009 to February 2020, prior to the elevation to the Court of Appeal, Supreme Court of Trinidad and Tobago. Honorable Justice Vasheist Kokaram.
Thank you very much, Mr. Gupta, for that comprehensive introduction. And it's such a delight to be part of this grand occasion for the 4th International Summer School. And it's such a privilege to be part of this exercise and initiative formulated by these three giants in our mediative circles: Nivaaran, Singapore International Mediation Center, and the Commonwealth Lawyers Association. I also want to thank Mr. Krishnan for conspiring to allow my wife to give me the permission to wake up early on our first day of court vacation to make this presentation to you all. Such a pleasure to you all. Good evening to where you are, good afternoon, and good morning. I did tell Mr. Gupta that right after my presentation, I'm running down to the Brian Lara Stadium to see the West Indies and India play their one-day international. Please, if there's a mediator out there, could you find a mediative solution for the West Indies and the Indian match? I will be grateful to hear. I want to look at goal 16, as Mr. Gupta comprehensively stated, of the United Nations Sustainable Development Goals, as it calls on a body of nations to promote peaceful and inclusive societies for sustainable development, provide access to justice, build effective, accountable, and inclusive institutions at all levels. Our common human experience has now found a birth in SDG 16, that without peace, there is no sustainable development. Without access to justice and an effective institutional framework to deliver justice, there can be no peace. So with those words, let me start my presentation. I'll share my screen. So I've looked at the topic of sustainable development, goals, and mediation. And the theme of my topic this morning, this afternoon, this evening is goals, aspirations, dreams, SDG 16, and peace jurisprudence, reimagining our future. And I would like to start with a clip, if I can. Just let me. There we go. Let me begin with this clip, and I hope you can hear the sound. Yes, Mr. Gupta?
Yeah.
Okay.
We can hear it.
And it continues and continues. This video shows a brief disagreement escalating into warfare. Do we have instincts for peace? And I use this video for my students to ask those questions. Do we have instincts for compassion? Do we have instincts for collaboration? Will our evolution as a human society be guided by instincts for sympathetic coexistence? If we say we do, and we begin with those assumptions, these are the cornerstones of SDG 16. And if these are the cornerstones of SDG 16 as an international aspiration of a future sustainable society, we must address today this picture of our collective present, revealing instincts of combat, instincts of insensitivity, instincts of dehumanization, and instincts of insularity. I also use this picture, this famous work of art, which I had revealed to you all last year in my talk, of Pablo Picasso, and I use it in my peace jurisprudence class. This is a famous, the art of Picasso. He was commissioned to paint a memorial about conflict and war. And it arose out of the senseless bombing of a Spanish town by the Hitler's Germany. And that town was called Guernica. And this is the famous painting, Guernica. A critic famously described Guernica as Picasso's letter of doom for all. All love is lost. And I've used this painting to graphically depict our present society of a never-ending cycle of brutality, not only playing out in our world in armed conflict, such as in Ukraine and Russia, the Russian conflict, but in our instinctive responses of individuals, communities, nations to be combative, to be self-serving, to be destructive. These instincts tend to frame our responses of our own institutions and legal systems to interrogate truth and justice in systems of combat, in systems of wars of attrition, in systems of empowerment of one at the expense of the other. And those types of legal systems and institutional frameworks perpetuate feelings of hate, validate feelings of revenge. It normalizes survival of the might, marginalization of the weak. These legal systems, our legal systems and our institutional processes are designed on a principle of competitiveness, isolationism, survival of the fittest, which are all unsustainable principles for the evolution of mankind. Charles Darwin himself recognized that the prime driver of evolution is not the survival of the fittest, but sympathetic coexistence or empathy and compassion for our fellow beings. His theory on natural selection to guarantee the survival of our species was not predicated on the survival of the fittest, but, as he said, in the capacity to demonstrate compassion to all sentient beings. And as he said, those communities which include the greatest number of the most sympathetic members would flourish best. So as we begin to grapple with the challenges of creating the environment of sustainable development envisioned with SDG 16, if we accept that a sustainable human society can only materialize in a peaceful world, what is our vision for peace? What is the peace agenda? What is the peace policy? What is the peace budget? These are the conversations that should be playing out in our national discourse. Where mismanaged conflict is the main impediment to our pursuit of peace, a main impediment to our progress, the pursuit of peace must dominate our local, regional, and international discourse. So SDG 16 places then peace at the center of our discussion in reforming legal systems, reforming institutional life. If we accept that there can be no justice without peace, then we need to inject a new meaning to justice for all, access to justice for all. Where is mediation placed in the wider lens of societal development and human sustainability? Should we see mediation as restricted to a ritualistic ADR process? Or can we cull from mediation mediative benefits that can be transferred into a social agenda to build stronger, more resilient societies that are adaptable to change and more robust to managing conflict? And it is that fascination of positive peace as a measurable and tangible outcome envisioned in Goal 16 that will inform our approach to conflict, which I will call care-fronting conflict and not confronting conflict, care-fronting conflict, which lies at the core of our theory of peace jurisprudence. That's a concept which I continue to interrogate at our legal clinic at the law school, and it is a concept which I would invite the esteemed bodies involved in this seminar to join with us in continuing to interrogate how this can inform and reform our legal systems to humanize our institutional response to conflict. And so if SDG 16 has put positive peace as an aspirational goal, we must treat mediation for all of its core values of compassion, collaboration, consensus building as the ideal platform to inform all our approaches to care-fronting conflict and mapping a sustainable future for us all. So what I would like to spend this afternoon, this evening, this morning with you is to look at SDG 16, its relationship to access to justice, why it's important to build, why this aspiration is important in building trust in our institutions, recognizing that SDG 16 is really a demand for inclusion, which is ushered in by a more informed public. And it's now time to validate systems that will give support and validation for inclusivity, autonomy in decision-making, and ownership of futures. And when we come to speak about PJ or peace jurisprudence, that concept calls for a synergy of peace as an output with justice, where there's no mysticism in the delivery of just results, where there's a focus on positive peace as an output of conflict resolution, and where participants are empowered to take ownership of joint, sustainable futures. And there's a greater focus on compassionate conditions for human progress. And so what I will cover with you in this time that I do have with you would be to examine two stories of conflict and mediation, a sort of self-reflection of some lessons learned from it. Examine our present reflex to resolve conflict and is it sustainable? To examine the core elements of SDG 16. We just reflect on some of our instincts of peace that we do have. What is the promise of mediation with SDG 16? And how can we reintegrate and reconstitute our institutional response with a peace jurisprudential outlook? And then last, I will end with our vision for us of sustainable development. Is it achievable under SDG 16? So let me start with two little stories. And you all have heard stories for this entire week, but permit me just to use these as two analogies. My first story is two businessmen, entrepreneurs in a small island state in the Caribbean. And this is an experience I had 2 weeks ago at a judicial mediation. They both formed a company in a very competitive business of post-production special effects. It's the first of its kind in the Caribbean. They were good friends. Their families were very close. They used to, as we say in the Caribbean, used to go on limes in the river and lime in the beach and so on, and they enjoyed themselves. But after a few years of operation, a dispute emerged. There was a disagreement as to the terms on which they had originally formed their partnership. One friend thought it was a joint partnership with shares being shared 50-50. The other one thought it was just simply I paid you a salary. That led to a dispute on the control of the company. It spiraled into litigation, multiple complex pieces of litigation on breaches of trust, oppression actions, corporate suits. One friend took away all the assets of the company and formed a new company, and eventually dissolving the first company. And they spent 10 years in this warfare. The family life was destroyed. In the judicial settlement conference, in the judicial mediation in which they engaged, in one session, they had resolved their differences when they had acknowledged the original worth of each other as friends, when they formed this idea which was unique for the island and unique for the Caribbean. They recognized the toll that this dispute had had on their personal lives and on their family lives. They expressed a longing for their families to be together again, and they vowed to plan to continue a business working relationship with much clearer legal lines of roles and responsibilities. It was that yearning for belonging and peaceful coexistence that threw them into a pathway of delineating proper lines of responsibilities. The second success story is the conflict in Kenya. And this is a famous story. In 2007, you all know of the election crisis in Kenya. There was a stalemate between the Kibaki-led PNU and the Odinga-led ODM. Both of them considered themselves winner at the polls. No one backed down. It was almost like the video that we saw, each one beating each other on the head as to who was the victor. And that spiraled into post-election violence when thousands were dead and displaced from their homes. Kofi Annan and his team intervened. It was not a traditional mediation. Before negotiating, they conducted stakeholder conversations with various sectors of society to get a multiplicity of views of the violence of different positions. And then they devised a tailor-made process of 4 components to deal with the dispute: ending the violence, promoting reconciliation, overcoming political crisis, and developing long-term strategies for durable peace. It soon became apparent to all the parties that the solution did not lie in legal mechanisms. And the negotiators began negotiating directly with the political leaders and not with the team. And there was a growing sense that, as the quotation here from Mr. Annan's book, that they recognized that adversaries or not, we had a collective responsibility which propelled us to upgrade our thinking, enlightenment, to appreciate that we are not adversaries. We held divergent views, and that's fine, but which need to be narrowed to achieve peace. And arising out of this facilitated dialogue, a slew of nation-building strategies, from electoral reform to truth and justice reconciliation commissions to police sector reform, a nationwide blueprint for constitutional change, legal reform to preserve the rule of law. I've used these 2 polar opposites of stories, and you're familiar with many of these stories of mediation, just to re-emphasize that from the micro level of the family, at the community level, to the national level and even international level, the stories are the same. One, we see the negative instinctive responses that we do have when a conflict emerges, which is harmful, destructive, and just like in the video, it spirals out of control. And second, if we carefront, we confront our conflict with care, carefront our conflict in the appropriate safe setting, what emerges are the building blocks of a sustainable society. And so we can cull from these stories and all the stories that you may have, and these are just some ideas, that our desire for peace, regardless of our instinctive responses we saw in the video and in Guernica, our desire for peace actually trumps our desire for negative conflict. The problem is we haven't been able to wire ourselves to find the path. Second, the maintenance and proper regulation of relationships are a key ingredient in the pathway to peace. It recognizes what Darwin says is true. We have the instinct for relationship. Simple misunderstandings, thirdly, could be just like in the video, could be the genesis of long, expensive, and acrimonious disputes. A fourth lesson is collaborative systems of dialogue are essential as important gateways to justice and peace. Not an institution talking down to someone, collaborative systems of dialogue. Fifth, the right atmosphere, however, must be created to harness our instincts for peaceful coexistence. Otherwise, we fall back into this combative wired reflex. And finally, compassion, collaboration, and consensus is the bridge on which we will carry disputants to a destination of peace. So what we take away from these stories of mediation are these lessons, and also 4 key takeaways on our instinctive responses to conflict that are important to understanding how SDG 16 can be realized through a theory of mediative responses and peace jurisprudence. Trust, truth, transformation, traditions. Let's take the first, truth. Even though we're wired to see the one truth and to beat each other over the one truth, our systems that we've designed to resolve conflict must be able to accommodate multiple truths. And this picture that we have here is a useful picture. You can put in the chat whether you are seeing a picture here of an old woman or a young woman or something else. For the first time I threw this up for some students, they said, "Judge, I'm seeing an animal." I said, "What? Where are you seeing this animal?" And I said, "Okay, if you are seeing an animal, what if I told you that it is only an old woman? Would you say I'm a liar? Do I say you're a liar? Do we go to court and beat each other to say it's an animal and an old woman?" Well, the truth is that there are multiple versions of the truth. And in this picture here, we have the old woman with a big nose here, or we have the young woman with the side profile with her eyelash and her little nose on this side here and the necklace and so on. So there are multiple perceptions to one reality. And the fact we do not associate with that perception of reality does not make it less valid. And so the success of mediation, as we all know, does not lie in the victory of truth over the other, but an empathy of the other. And all our studies of procedural justice tells us just that disputants who even come to our legal courts place a higher premium and higher value, not on victory, but on having voice, on being treated with respect, on being treated with someone who is neutral and understands my situation, and in building trust. These are the values that we place at a higher premium than simply getting my truth to be victorious. The second thing coming out of that on procedural justice is building trust. And we are in a crisis of mistrust. And in the famous novel by Banfield, A Village of Mistrust, he described in his Edward Banfield's text, The Moral Basis of a Backward Society. He described a village in the 1950s mired in poverty and ignorance. Why? Because the villagers were unable to get together for a common goal, because they were all affected by the assumption that everyone was acting for their own selfish material interests. So no one trusted each other. So neighbors could not pool their limited resources for more efficient farming. A farmer who planted 6 fruit trees will wake up to see it destroyed. Fathers told their sons not to disclose the truth of what you owned, as it would invite theft. And the mayor of the village will turn down help from others because he was fearful people will ask him how much you took for yourself. That vicious cycle of mistrust left them in an unsustainable and undeveloped condition. And this was his theory, that the inability of villagers to act together for the common good. In this culture of distrust, there were no leaders and no followers. So the key element of mediation, of building trust, is so important for a transformative goal to achieve a peaceful society envisioned in SDG 16. Thirdly, we must learn to embrace conflict, transform ourselves through conflict, and use conflict as opportunities for building pathways of a sustainable future. I quote that, and it's a from Osberg's theory of carefronting conflict. So we cannot look at conflict as simply as something that should be brought to a swift end. There must be learning lessons from conflict. And I think Mr. Gupta had mentioned that in peace mediation, of looking at the origins and finding out what are the ways in which we can build sustainable futures together. And finally, we have this cult of I-ism, the focus on the individual, rather than seeing ourselves as a community, that we are all related. And so that survival instinct of self-preservation needs to be reformulated with a very empathetic understanding that we are all in circles of relationships. And that's very much intrinsic with our own DNA, for our own instincts of peace. And yes, you would have seen in your lectures earlier during the week of the indigenous systems that we all have before it was transplanted by the Anglo-Saxon legal system of determining truth and justice. We've all had our own instinctive pathways of peace, whether it's in Africa with the elder systems, whether it was in India that we've borrowed in the West Indies and Trinidad and Tobago of the Panchayat system, whether it's in China. These are all systems that were community-based, that I would describe it as a circle of elders who are invested with compassion and empathy in working out a sustainable future for the entire community. Those instinctive responses are indeed part of our DNA. And so when we come to SDG 16, it's no mistake or no surprise that the common humanity of all the nations in the United Nations are looking towards this instinctive of building on our instinctive desires for promoting peaceful and inclusive societies. And so sustainable development, as defined and understood in the SDG 16 and in the SDG goals, is the development that meets the needs of the present without compromising the ability of future generations to meet their own needs. So again, that in itself debunks the theory of I-ism, promotes the theory of collectivism. It contains with it two key concepts, the concept of needs, in particular, the essential needs of the world's poor. You see how we are formulating the question of needs as opposed to truths. What are our undercurrent, the undercurrent of the needs of our society, to which overriding priority should be given, and the idea of limitation imposed by the state of technology and social organization on the environment's ability to meet present and future needs. There are 15 goals. There are 16 goals in the SDGs. In goal 16, we do have 10 agenda items, which includes reducing all forms of violence, ending exploitation and trafficking, promoting the rule of law, reducing illicit financial arm flows, importantly, developing effective, accountable, and transparent institutions, ensuring responsive and inclusive and participatory decision-making, broadening and strengthening the participation of developing countries, and strengthening national institutions at all levels. And the key pillars for mapping the future under SDG 16 are the concept of peaceful societies, the concept of access to justice for all, the concept of inclusion, the concept of accountability. And all of this leads to a sustainable rule of law, vital for a sustainable human development and society. I pause just to mention the concept of peaceful societies under SDG 16. These are the principles that they have enunciated. Culture of peace through education, building a culture of peace through education. A peaceful society is one that is a sustainable economic development. It's one where we respect all human rights, that there's equality, no one is marginalized or left behind. Participatory communication, free flow of information, internal peace and security, understanding, tolerance, and solidarity. It was very interesting in the SDG 16 when they defined peaceful societies, that reference was made to the Economic Institute's Global Peace Index. I shared that with you all at my last lecture, and I thought I would share it with you again in terms of the 2023 Global Peace Index. This is a compilation and a review of the global world's aspirations and achievements of positive peace. And they've been able to measure the achievement of positive peace through using 7 pillars. That is, do these societies have a well-functioning government? Is there sound business environment? Is there acceptance of the rights of others? Do they have good relations with neighbors? Is there a free flow of information, high levels of human capital, low levels of corruption, and equitable distribution of resources? So it captures and measures the concept of peaceful societies espoused in SDG 16. And it's interesting to see how they have looked at peace. And I use this concept as a measurable output when we are formulating our theory on peace jurisprudence to reformulate and redesign our legal processes as a foundation of building a sustainable future envisioned in SDG 16. A positive peace is seen as providing the necessary conditions for adapting to changing conditions, a well-run society, non-violent resolution of disagreements. It's the guiding principle to build and reinforce attitudes, institutions, and structures that preempt conflict, help societies channel disagreements productively rather than falling into violence. If ever you wanted a statement of the underlying theory of a mediative intervention and mediation itself. It's here. Achieving, as Mr. Gupta was mentioning, peace mediation. These are the ambitions. And I thought it was interesting to also recognize that these peace theories have come from a long history. From we can reflect on Tolstoy's letter to Gandhi, his letter to the Hindu, where Tolstoy recognized how important in the peace thrust that love, compassion, that's the only way to rid humanity from all its ills. That concept of love and compassion was taken up by Gandhi, as we all know, on his concept of nonviolence, the relentless search of truth. And those concepts build into Johann Galtung's theory of positive peace. And he built the theory that there are two concepts of peace: negative peace and positive peace. Our legal systems are built and wired, and our instinctive responses to conflict is built on negative peace. We are looking to end the conflict, put a timeline on the conflict and give you a result and say, that's it, take that and go. But positive peace is a more lasting peace, as it is built on sustainable investments in development, building institutions, societal attitudes, looking at peaceful coexistence, in fact, creating human conditions for sustainable change and development, SDG 16. So what if we had seen that positive peace should be the output of any interaction with institutions, the output of the legal process? How would we reformulate our concept of access to justice and the rule of law? Interesting statistics in terms of where we rank on the positive peace index. Iceland is #1, and we have some developed countries there, Denmark and Ireland, New Zealand. At the very bottom, we have Afghanistan. We have Trinidad at 70, some of the Caribbean countries in the middle of the index. We have India at 126. And I thought that it is interesting. There was another report that feeds into the concept of SDG 16 and the rule of law index of the World Justice Project report. And that rule of law index actually had looked at the concept of mapping and measuring the achievement of rule of law across the globe. It's a standard which builds trust and accountability in our institutions. The rule of law is a principle of governance, guaranteeing equality before the law, ensuring laws and norms are equally enforced. As with the sustainability of peace, to sustain the rule of law, it requires adherence to principles of equality, accountability, fairness, participation in decision-making, legal transparency. And mapping those pillars, again, they were able to say, well, Denmark again is #1. You see the synergy between rule of law, achievable goals, and positive peace index. And you can put it the other way. If we are able to develop or look at those pillars of positive peace and we are able to attain it, then there is a natural synergy with achieving and observing and enhancing the rule of law. Trinidad as well and is in the middle. India has a higher ranking with the rule of law than its positive peace index, and it's quite interesting. These indicators in the World Justice Forum Action Agenda of 2019 put these key criteria as pillars of achievement for attaining a society that observes and enhances the rule of law. People-centered justice systems. I mean, we should look at what they're saying about the rule of law. People-centered justice systems. And our own instincts of peace, of communal dispute resolution systems and mediation, cross-sectoral collaboration, enhanced and it's promoted through mediative practices, meeting people justice needs and protecting human rights. Again, people justice, people-centric justice through mediation, commitment to accountable progress. That is the sustainable goals through mediative interventions. So there's a natural synergy that we are seeing between these lofty goals and aspirations on the SDG 16, Positive Peace Index, the Rule of Law Index, and mediation. Mediation I look at in this section as the invisible bridge that bridges or disputants. And I've always gotten into trouble with this, that people that say that, look, you go to mediation just to settle a case. Well, no, it's much more than that. It's much more than that. It's about having a dialogue and conversation. It's opening the doors to understanding and treating with different views and multiple truths with empathy and compassion. And those are the ingredients of building a sustainable society. And this invisible bridge of mediation assists us to weave together in our social fabric a society that achieves SDG 16 of giving voice to everyone, of building trust, of enhancing access to justice, and creating an environment of organizational peace. And so I agree with Mr. Gupta that mediation is more than just about settlement. It's a peace process. And what we've done in our peace jurisprudence clinic is to look at the mediation. What are the core elements that makes it such a success in achieving these conditions of positive peace and sustainable development goals of SDG 16? And the three very simple elements of promoting collaboration, empathy and compassion, and consensus building. And if we take that and invest it into our legal processes and invest it into our systems, legal systems, in our response to conflict, we begin to see and reconstitute our institutional response to align itself to positive, peaceful outcomes and a sustainable future. Michael Sandel had said to us that to achieve a just society, we have to reason together about the meaning of a good life to create a public culture hospitable to the disagreements which will inevitably arise. And we've been trying to do that in our peace jurisprudence clinic by looking at all the disparate strands of legal theory that are people-centric, that are collaborative in nature, that are empathetic, that are healing. These are the sustainable goals for our future. And we have problem-solving legal principles. We have collaborative lawyering, restorative justice principles, therapeutic justice principles, procedural justice principles, transformative mediation, peace mediation, problem-solving courts, holistic justice, all of that feeding into a theory of peace jurisprudence which democratizes our systems of justice and makes it more participatory, creates more trust in that system, and validates a system of access to justice for all, making it more meaningful. And so our strands of peace jurisprudence, which I think aligns itself to SDG 16, is promoting a judicial humanism, a process which will place positive peace as the outcome, gives priority to reconciliation. We pursue restorative and therapeutic goals. We harmonizes parties' goals. There's judicial encouragement of self-determination, collective autonomy. And in doing so, we build greater trust in achieving joint futures. Our working definition of peace jurisprudence that we are interrogating, it's not final. It's a combination of mediation, restorative justice, collaborative law, therapeutic jurisprudence, and solution-focused practices. It's a process by which the law places the concept of positive peace as an outcome beyond simply the legal resolution of a dispute. It's not just negative peace, which is the end of a conflict, but creating conditions for sustaining a peaceful society. It recognizes that judges and lawyers play a leading role to create this environment for positive, peaceful change. And so the law must be carefully analyzed for its impact on social realities. The legal process must engage and modulate it to individual needs, and lawyering and judging must be transformed to be felt to be more humane. And in this way, human jurisprudence can form the backdrop of social justice, community building, and nation development. And so it synergizes with the goals of SDG 16. So we look at peace jurisprudence as this Caribbean cocktail. I say when you come to the Caribbean, you know, you come, you relax, you lime, we are very hospitable. Like we will give India the cup this afternoon. You know, if we do that, well, we are a loving people. And that love and that empathy is something that should be infused in any response to our legal response to conflict. And these are the 12 elements of PJ that we will interrogate in our legal clinic. And I will share with you for your own thinking that disputants are not a statistic. They are people, they are us. We have to create the right environment for them to arrive at peaceful outcomes. Empathy and compassion, building hope, future orientation, acknowledging history, acknowledging family and tradition, co-opting help, recognizing the problem, ending revolving door disputes, putting peace as a substantive outcome nationally. If these are the goals of a legal system, then we would have radically transformed our legal process as we have it now. And we have something entirely new, something entirely relatable, something entirely sustainable. And so I end then with just a simple blueprint for tomorrow. What can we do as agents for change? What can we do? And so I just leave with you that SDG 16 is a laudable objective. It's an aspiration which should be interrogated in our institutional life. Let us rethink our legal process. And we can think about adopting a credo of collaboration, working together, not against each other, in every level of society. Adopt a mediate first pledge, integrate mediation processes in our institutions, sensitize and build a culture of listening and caring, creating peace cities, symbols. Look for symbols in which we can create and sustain this theory that positive peace is important, and how can that be achievable? Reform our legal education to become more collaborative. Reform legal education to take away the adversarial approach and to put positive peace as the center of our endeavor. And if our judicial process is to integrate peace jurisprudence, we would have evolved and transferred our legal institutions into peace hubs in the virtual space or even in the physical space. That is indeed an achievable goal and a sustainable one. And so I end and I leave with you that even though the world of conflict is complex, any system that debunks a collective approach to solving problems is unsustainable. SDG 16 and the goal of peaceful, inclusive societies and justice for all and humane institutions is the future, is an aspiration, not only a dream, but an achievable goal. Preparing, the best way to prepare for this future is to invent it. And so let's take ownership. As mediators, practitioners, let's create this culture of carefrontation and collaboration. Let's humanize our institutions and legal processes, and let's infuse love into our instinctive responses to peace. And I leave with you my little message of love to all of you listening. Thank you. Oops.
May you find peace anywhere you come from. Coulda up, you coulda down. Blessings on my nation. Ooh, yeah. Oh yeah, oh yeah. This city can't hold me. My vibes too
Peace and love. Peace and love. Thank you very much.
That was absolutely magnificent, outstanding, delightful talk on UN SDG 16. Beginning with a clip when the human existed in Stone Age. Suddenly one discovers a diamond and there's a conflict of interest, not sharing of the search, but it led to a physical fight, to evolution of modern warheads, and finally an atom bomb. That's how we started. And that was absolutely amazing. Now, even thereafter, that's the beauty, that's the worst part of it, or I don't know how to take it. Even thereafter, the cycle of dispute continues as divergence of views, differences, multiple perceptions of truth are not appreciated and respected. Instinct of ism as counter-distinguished from instinct of peace. That is what Justice Kokaram referred to. It's so amazing. The misunderstanding is the genesis of long, expensive, and acrimonious disputes. Justice Kokaram's blending of sustainable peace with justice for all is commendable. His emphasis that mediation is not merely ritualistic ADR process, but is imperative for societal development, human sustainability, enable society to become stronger, resilient, and adaptable to change, and manage conflict by respecting differences was so perfectly articulated. His stress that mediation lies at the core of peace jurisprudence, and peace mediation as a part of SDG 16 has compassion, collaboration, consensus, building trust at its core is the future of our sustainable human development, are the great words of wisdom. Justice Kokaram's reference to Tolstoy's letter to Gandhi was very close to my heart. It is one of my favorite letters. That letter was the reason of forming of Tolstoy farm in South Africa. He did not make anybody's name, but he used Tolstoy. And Gandhi, and it was the basis of achieving the independence of India by non-violence. It was almost the last letter which was written by Tolstoy to Gandhi, as by the time the letter reached Gandhi, Tolstoy has expired. And it talked about love and the conflict that was existing, because though they were teaching love, but they were fighting with every neighbor and everybody around. Now that is a wonderful letter in fact. Thanks to Justice Kokaram for sharing such clear vision. Thanks to all the participants for being with us. We now come to the question and answer sessions. We have already received some questions. I will request all the participants to continue to pose the questions in the chat, and let's hear Justice Kokaram one by one. The first question comes from Mr. Kishore Dere. He says, can mediation help resolve differences between the global north and south to facilitate transfer of clean technology without IPR barriers?
Well, it's all about, I think, designing the right system. And I think that's one of the messages that we can learn from just that simple example from the Kenyan crisis, that not every dispute you face every dispute and every disagreement with the same approach. Understand needs, interrogate what is desired in the different communities, in the different nations of the North and the South, and then design a system where we can collaborate when we can achieve mutual goals. And I think that will be important. Right now, the problem with the SDG 16 is that it's being espoused by nations who perceived to be taking advantage of the South, taking advantage of others. And we have to find a bridge to try to demystifice that trust and put everyone on the same level playing field. And without that, we would not achieve a sustainable future. So that's a great challenge. It's a great question. Thank you, Mr. Gupta.
The next is by Dhruv Teja. It is not a question, it is just an observation. I'll just read it as an observation. Mediation on theoretical front is undoubtedly good, but in practical front and mediation, the mediation did not succeed. It appears an element of force is required to keep peace as an ongoing process. The Ayodhya episode is an instance where mediation not succeeded, but the Supreme Court judgment ensured some sort of a peace. mediation did not succeed in international area. So that's more of an observation. So let's skip that. I go to the next question by Abha Sharma. How far mediation is helpful in achieving sustainable development goals?
Yeah, I think in every mediation, once it's done correctly, and I think I think we need to make the difference between maybe going into a mediation just to settle a dispute, as opposed to mediation with a view to looking to build sustainable futures. And if you take that latter approach, you will have a synergizing between your mediative processes and a sustainable future. I know it's very easy for us as mediators to go in and say, okay, good, we got a settlement. Let's run out the room. That's it. We signed off. End of story. But it could be short-sighted. It could be that, we didn't think things through, and next thing you know, they're fighting over the peace deal. So it takes a lot of effort. It takes a lot of digging as to what are the cornerstones of a sustainable future. So I hope that's the best answer I can give you, Mr. Gupta.
Next, we have got Dr. Kishore Dere. What is the likelihood of mediation paving the way for justice to reach out victims of climate change?
Yeah, so actually mediation plays a very important part in environmental issues, in sustainable development on climate change matters, and in fact could be more and is in fact more effective than perhaps dealing with these environmental challenges in our court systems. Again, a question of designing the right system for dealing with global climate change issues, getting the right people around the table, getting commitment, building trust, and again, building pillars for a sustainable and enforceable future dealing with climate change. I mean, the whole concept of making national commitments to bring down our green gas emissions, again, there's an element of some nations being disadvantaged. Again, there's an element of lack of trust. All of these are challenges that we have to bridge on an international scale for us to get true peace and equality and equity on an international scale through mediation efforts.
I think that's absolutely true. And this climate change issue will lead to serious mediations coming up over the years. Then Dhruv Teja, again, we have got I would say a mark. He says how Denmark and India is comparable. They vary by several parameters. Belittling India on this may not be warranted. I don't know. Again, it's a question. It's again an observation. It's not a straight question. Then
I would just say that we take all these positive peace indicators and rule of law indicators. We take all of these with a pinch of salt, everyone. These are all international bodies looking at us. And I will always say, don't let people dictate us. Don't let people label us. But it's important to reflect on what those labels are and to address it. But I wouldn't allow that to dictate me. So that's just my 2 cents.
Yeah, because every country has its own culture, its own heritage, its own slotting. I always use the principle of slotting. I said you're slotted the way you're slotted. You can't compare anybody with anybody.
That's right.
That's right. Very important. So let's go to Jyoti Tiwari. The next question: how can we create a resolution that not only address the immediate concerns of the parties involved, but also promoters long-term sustainable outcome?
Yeah, it's difficult, but it's not unachievable. And my only advice is have patience, have foresight, and even in the judiciary, we are all lawyers and judges alike, expert dispute resolvers. That's what we need to look at ourselves as. And every case that comes to you and every client that comes to you, we are designing a special system to deal with that conflict. There's no cookie cutter approach. So I hope that answers.
I totally agree with that. That's absolutely, and that is where I disagree with the typical Montek error issue that legislation creates a law. I said the judges create law every day. Where every case they are creating law. That's
there you go.
We are in fact we are creating the law. They are legislating the law. So they are only doing what their job is, but the real law is created in every case.
Yeah.
Every case creates
Yeah.
a law.
Yeah.
Next is by Swapnil Goswami. It is how can one define negative peace and how does it vary from the positive peace?
Right. So yeah, so negative peace just focuses, like I said, on the end of a conflict. And so our legal system is based on that. So you have you bring your conflict to one stage, you have an appeal to another stage, you have an appeal to another stage, 3 stages, but it's time sensitive. There is a time when that conflict has to end. And it's simple, it's like in warfare. There will come an end to the war. And you're concerned about just bringing an end to the war, just perhaps pulverizing the other side until there's no more. That's the end of the conflict. But yes, there'll be no violence after the war is over. But who's left? Who survives? And so positive peace now is now focused on not just ending conflict, but creating an environment for progress. And I think that's what we miss when we do our judgments. Yes, we think that we are giving you the principles and precedents so that you can now abide by, but there's a gap between that and reality. There's a gap between that and human condition, and there's a gap between that and sustainable futures. And that's the gap that I'm hoping that we can fill with a peace jurisprudence approach if we think about positive peace as the outcome rather than just simple negative peace.
I think that's so well said. Neelam has raised a question. What is the valuable suggestion for new mediators?
That is a very good question. My advice to new mediators is to see yourselves as an indispensable part of your society, as peacemakers, as persons who are sensitive to the needs of society. See yourselves as bright lights to lead the way to persons who are in despair. And I'll tell you this for mediators, it takes a while, it takes some time, but embrace the emotional conflict. Go in and immerse yourself in that pain and help your disputants find a path. It takes a toll on you, but after a while, you start to dance with the music, you start to sing the songs and so on, and you start to enjoy all what we see in Trinidad and the Caribbean. You enjoy the bacchanal of conflict, and you work out solutions. So enjoy it. Have extreme patience, but enjoy it.
I think one of the most important things we need as a mediator is emotional maturity.
Yes.
So we need emotional maturity, and that and a worldly view, the largely worldly view, as I call it. You have to see that. One of the last questions coming up, Sarthak Singh, what can be the different ways of providing legal education to ensure peace, justice among people?
What? Could you repeat that? What?
He says, what can be different ways for providing legal education to ensure peace, justice amongst people? I thought everybody should be shown the clip that you started with.
Yeah, no, that's true. I think peace education needs to be part of your curriculum at your law schools and legal training. Collaborative lawyering is a practice that should now be developed in our law schools. Adopting a non-adversarial approach, and I think that every lawyer that goes to law school needs to be trained in mediation and be developed as not everyone could be a mediator, but at least be aware of the process and adopting mediation skills. And all of the comprehensive law movement that I showed on this slide of therapeutic jurisprudence, procedural justice, all of these things we are missing at the law school. We need those to be taught to our lawyers. And and remember, the lawyers will be the pool from which your judges are chosen.
That's it.
So you are actually transforming your legal process.
Okay, that's it. Absolutely. So well said. And I think it must start from the very beginning itself. In fact, we were doing something where they're taking law to schools, but not in law schools. And I remember Santhanan telling me about you bringing young children and telling them how they fight and how they resolve the problems.
Yes,
So
yes.
that's
So
a
peer mediation, even at
peer
the
mediation is a.
schools, it's so vitally important. Yes, yes, yes.
So now we come to the last question. I think that's it, and then we go to the end. Peace. This is by Mrinali Srivastav. Peace jurisprudence advocates negotiated justice, not equity or equality before law. How is it better than the adversarial legal system?
Yeah, because you get closer to a sustainable goal, which is durable solutions, more peaceful outcomes, more acceptable outcomes. I mean, how many times we see people coming in an adversarial system trying to get an outcome, and both of them are not happy with the outcome. And even this concept of one winner, one loser, that spirals into further acrimony, which is not seen by our court system. So I would always emphasize the question of collaboration and consensus building through compassion and empathy.
Absolutely right. And I think if you look at it, the Second World War was really because the First World War Versailles Treaty, but did not. It was a lopsided treaty. So it was.
But it has to be, you see, because again, negative peace will give you short-sighted peace deals. You know, so again, just be sensitive to needs, outcomes, sustainable futures, and design appropriate systems to deal with each conflict in its unique way.
So almost the last question. I'm not taking any more question now. This is by Dr. Kishore Dere again. Can there be an external peace without having an internal peace in a restless and ambitious human mind? That's a very interesting question. That is why I raised that issue.
Yes, no, it's true. And many theories would say, well, you know, you have to have peace within. And I think one of the things that I talk to disputants about, even in the mediation, is that we're trying to achieve peace, not even external peace, but if we can have peace within ourselves and acceptance of an outcome, or reconciliation within ourselves, that too is a pathway to peace, internal peace. That's a good question.
Okay. So now that a great thanks to all the guest speakers, hosts, and all the organizers as the curtain falls today with this 10th and final lecture of the 4th International Virtual Summer School conducted by Nivaaran, along with the Singapore International Mediation Center and Commonwealth Law Association. I have special and very special thanks to Peter Maynard, the president of Commonwealth Lawyer Association, who has been present all through all the 10 days, and Brian Spear, who was the past president of Commonwealth Lawyer Association, who has been with us on all these days. And you know, these are they're extremely motivating factors for particularly the young lawyers, because when they see these stalwarts and all these people joining us, it's really a great support to the structure. And all these, you know, the value of these summer schools are really worth it. That is what we feel now. Just another thing is that Mediation Bill 2021 was considered by and discussed and adopted and passed and amended by the Rajya Sabha today. So it was much awaited and a great support. I think there's a new step for the Indian mediation to come up and go ahead with it now. Now, my special thanks also to all the participants for their patience. And every day, you know, we have been crossing almost like 200 participants on the virtual joining us. Their perseverance, their attentiveness, and effective participation by constantly asking very relevant questions after all these lectures. Tomorrow is the August 2nd, 2023. We have a closing ceremony beginning at 5 p.m. The chief guest for the closing ceremony will be Honorable Justice Ujjal Bhuwan, Judge, Supreme Court of India. Host for the closing ceremony will be Nandini Gore, advocate, author, and seasoned mediator. Welcome address will be by our dear Rajiv Datta, a senior advocate and another senior seasoned mediator. Welcome guest for tomorrow will be Laurie Pulitza from Canada. She's the Vice President of CLA Americas, and Sukumar Padjoshi, the present Vice President of the Supreme Court Bar Association. The vote of thanks will be by Raki Buddhiraja, advocate and mediator. With thanks to all once again, We, Nivaaran, SIMC, and CLA look forward to meet you again tomorrow. The invitation for tomorrow is not just for the registered participants, but for one and all. All are requested to forward the post of the link tomorrow for the closing ceremony to all the groups. Thank you. Thank you very much.
Thank you. Thank you very much.
Thank you, Vasheist, for that wonderful presentation.
What a wonderful.
Thank you. Thank you,
Really
gentlemen.
enjoyed it.
I'm going now to my match. And I don't know what a mediated outcome is. It that I can't even get a tie.
Wish
If
you
you
all
have a tie, you have a what the final the final what do you call that when you have a tie?